lawsuit.
Yeah.
The third one that was filed. Total.
I don't know that. See,
Okay.
I don't do that. I just
right.
fight.
All right. My next question is about Mike Decker and Tom Sanders. And
That's it on pain? Go ahead.
well,
He deserves 5 more minutes.
Well, let me
Go
ask.
ahead.
No, let me ask.
He's more interesting than the Decker guys.
At what point did you decide that? Were you involved in the decision to essentially fire Mr. Payne?
I'm the one that gave up. I'm the one that ended it because I couldn't. He really ended it. I'm the one that had to acknowledge it, and then it took a while for Carol and her mother to, realize it. He's a very, and it's just he's just a unique guy. He's a different kind of lawyer than most lawyers, I guess.
There's a document I'm looking for that I can't find.
What is it?
No, I know the document. I just.
Get over the objection thing over here on the Decker and Sanders.
All right. Can you all just spot me 1 minute to go grab it?
Yeah, I got to go to the bathroom again. I take the medicine and it makes me happy.
All right. Well, let's just make this a super short break and then we'll come back. Thanks.
On the record, 222.
All right. Ms. Honerkamp, I'm presenting you a document we'll mark as Exhibit 5. I got copies for Ms. Davis, for the counsel for Mr. Davis,
At the top.
Ms. Matlock.
Say, I do the wrong thing about it.
All right. Now, Ms. Honerkamp, Mr. Viata, who I work with, got this fax from you. It appears Carol Davis signed the cover sheet. Is that? No. Okay, then that I don't know.
She didn't sign my cover sheet.
Okay,
when I sent it.
that's fine. So that signature, you know nothing about.
I don't. Is it my signature?
Yes.
Okay, I could have.
It's just to mean that it's about me.
Like in Ray, Carol Davis. Thank you. That's okay. So regarding Carol Davis, we get this fax here. Do you remember sending this?
I remember it now. Yes.
Okay. While we're talking about problems with Carol's lawyers, kind of got a theme going here.
You didn't mention that though, but I will acknowledge that as being discussed anyway.
The what?
Go ahead.
Okay. Do you remember writing this letter to Mr. Viata and Miss Orr, who I was on the pleading, but for all intents and purposes, I'm Miss Orr now. So.
Yes, I do recall writing the letter. I don't recall sending it, but I remember writing it.
Okay. Well, I'd like to ask you about some of the things in the letter.
All right.
The first says that first sentence is, I'm notifying you as counsel for the city of Jersey Village, and all that includes that I believe crimes have been committed. Okay, well, what crimes were you talking about?
I listed them, I believe. 1, 2, 3, 4, 5, 6, 7, 8, probably 10 or 12. But I listed them, I think.
All right. Well, let me ask a question in a different way then. What crimes were committed by Mr. Sanders and Mr. Decker in the handling of Miss Davis's case?
Oppression. I've been told fraud. I've been told legally that it's fraud against the court or fraud against her, which is the court. I'm not going to say the word conspiracy because I think it is. I think this is what happened was wrong. I think it's illegal. I've been told. I was told initially it was wrong to oppress her or to restrict her or to
Okay, so oppression and fraud would be
Well,
in conspiracy.
on this date, yes, but I had the reason that this was written was because of what happened prior to this date. You know, the week before. It happened when she hired them during the time it was ongoing. But this was the reason that I wrote this is that I felt isolating this case, this particular argument. If I had to argue it before a judge or argue it before you.
I'm just asking you what crimes you thought they
I'm
committed.
saying oppression and fraud from what I've been told to believe. I mean, I didn't just, it's hard to say when you write a letter like this that you can be advised, you cannot be advised. I was advised, and then I was not advised, and then I was advised again, and then it was said you have to make your own decision.
By who?
By Barbara Palmer.
Oh. Well, and she was your lawyer?
Yes.
Okay, you don't have to talk about.
My problem was she's the only counsel I could talk to about it.
And you had hired her.
I might have talked to somebody else.
Please stop, because had you hired her to be your lawyer? Because if you had hired her to be your lawyer and you were asking her questions in that context, I don't want to get into conversations that you and Ms. Palmer had when she was your lawyer. That's the
issue I don't understand now. I don't know if she is or not, or was then. That's the issue I don't understand.
Okay.
But at that time, she was under the context of being the lawyer that had contracted something with. She had been the.
Were you paying her?
Yes.
Okay, then let's just not talk about what you and Ms. Palmer talked about.
But this was my decision.
Okay, I don't want you to think that you have to answer.
No, it's just my decision.
Okay,
I had to make a decision.
Okay.
I made it.
I just want to make clear to you that
I made a decision.
Any conversations that you had with Ms. Palmer while you had hired her are attorney-client privilege.
I'm saying this was my decision and my expert in what I've had to go through and what I believe is wrong.
Okay. The second paragraph has a sentence, and that's going to get to this, which you brought up. I'm notifying you that I have an interest in this case in the form of a contract with the plaintiff, Carol Davis. And I was going to ask you what that contract was, but I think you brought it today. Is that right?
Yes.
Isn't it amazing how that works? All right.
They had it.
Who's they?
Wait a minute. Wait.
Sorry. Who's they?
Dicker and Center had it.
All right, so I'm looking now at exhibit number 6.
Payne had it.
Okay, Payne had it, Decker had it, and
anyone that represented Carol Davis had a copy of it.
Will you read it to me?
Lindy Honerkamp gets 50% less costs for recovery of all litigation. Carol Proctor Davis, October 1st, 2001. It's signed by Melinda Honerkamp and witnessed by Joe Stell, S-T-E-L-L.
Okay. Let me ask you a little bit about this. October 1st, 2001, when you said recovery of all litigation, is that limited to this lawsuit that we're in, or are there others?
It was just at the time, it was getting, very serious for me, money-wise, and I didn't have anything in writing, and I didn't, and it wasn't written. It was written like we wrote it because we didn't know what else to write. But it wasn't for pending litigation. It was just for that day. We had a hell of a time.
Well, I'm not.
But that's
you seem to be laughing at this. Is as far as I can tell, this is a valid contract.
I didn't say it wasn't valid.
Okay.
I said it's hysterical. It is odd. The way we wrote it was how we meant it. Was we didn't. You know what I mean?
Okay, well, that's what I'm asking you.
There's a reason we wrote it like that, and it makes sense to us, but it doesn't make sense now.
And what I'm trying to do is what courts often do, and lawyers often do, and people often do when they're looking at a contract is they're trying to figure out, what it meant and what was the understanding at the time. And so, at the time of October 1st, 2001, what litigation were you talking about that was either foreseen or covered by this?
Well, initially when I started in January '99, I did not expect all this to happen. It was not an issue. I mean, it wasn't something that I said, okay, I'm sitting at the table like other. I'm different than other people. I don't sit around going, I don't talk money. I don't like to talk about money. Making a living